This is Michael Popok, and this is Legal AF After Dark. Immunity, you've heard about it, but do you know exactly what it is, as Donald Trump's trying to use it both in his civil cases to avoid liability and in his criminal cases to avoid prosecution? What is it? Is it in the Constitution? If it's not in the Constitution, why are we talking about it? What will the D.C. Court of Appeals do that's handling the issue of whether Donald Trump can get his indictment dismissed at the appellate level? What are they going to do after oral argument that's just a week from tomorrow? And then does this case get to the United States Supreme Court? Do they take the case and make a ruling, or do they not take the case and send it off for the trial in March? Well, if those are the questions you like to have the answers to, you've come to the right place, Legal AF. Take a listen to our most recent episode.
We are headed towards, I think a prompt adjudication of this appeal by the D.C. Circuit Court of Appeals. I know last week and last episode, a lot of people saying, the Supreme Court denied special counsel Jack Smith's petition for certiorari or direct appeal. And you and I were saying, I get why the Supreme Court did that now. We'll have to see what the Supreme Court does after it goes through the normal process. I mean, Jack Smith was being as aggressive as you can be there and trying that direct appeal with the Supreme Court and saying, I don't even want to go through the D.C. Circuit Court of Appeals. And I think the Supreme Court looked at how fast the D.C. Circuit Court of Appeals was moving. When Jack Smith made that request to the Supreme Court to hear it on a direct basis, the D.C. Circuit had not set that super expedited schedule, either. So I think the Supreme Court said, look, the D.C. Circuit's going to have oral argument on January 9th. You got Trump's brief December 23rd. You've got Jack Smith's brief December 30th. You got Trump's reply January 2nd. Look, I think the Supreme Court said, what we're going to hear this during, Christmas and the New Year's? No, we're not going to hear it anyway during that time period. And so the D.C. Circuit's doing their work. Let's let them hear all of these arguments first, and then we'll hear it. And look, that kind of patience, I know when our democracy is on the line to be like, well, give it 30 more days or give it 45 more days. Every one of those days feels like a miss if Donald Trump's not being held accountable. So I totally get that. But Popok, just think about all the powerful arguments we're hearing now, not even just from Jack Smith, not Jack Smith's team, but from these, amicus briefs that are being filed by these outside groups. You had a few major ones, lots of former Republican groups coming together. You had the former White House top lawyer, Ty Cobb. He'd be the one who would be asserting absolute presidential immunity. So when you have the former White House lawyer, the top lawyer at the White House, Ty Cobb, join an amicus brief saying that there is no absolute presidential immunity, that's powerful. But then there was this other one that kind of snuck up on me, and I didn't even think through this argument. But when I read it, I was like, that's a pretty interesting argument. The group's called American Oversight. They're represented by top law firm Arnold Porter K. Scholer. I didn't realize that Arnold and Porter and K. and Scholer merged back in 2017. I still thought they were two different firms, but they're one firm, Arnold and Porter K. Scholer. And they basically argue there's no jurisdiction for this appeal at all. And they say, look, there's this case called Midland Asphalt, 1989 case. Justice Scalia, right-wing justice, since passed away, strict textualist. And Justice Scalia in Midland Asphalt said, you can't take these interlocutory appeals, these appeals in the middle of the case. That's what an interlocutory appeals on what's called a collateral order, and not a final order, an order that's in the middle of the case. He says, Justice Scalia said, unless there's some strict textual support for the immunity or grounds for this interlocutory appeal in the Constitution or in a statute. And so American Oversight says Donald Trump's absolute presidential immunity argument tries to take this bizarre contorted negative inference of the impeachment judgment clause, arguing that because there wasn't a conviction in the Senate, that therefore he's not entitled to therefore, he is entitled to absolute presidential immunity. But American Oversight says, even if you accept his argument has some basis in logic, which it doesn't, that's not in the Constitution. and there's no statute. So therefore, you need to address those issues, DC Circuit, after a conviction. This should not be an interlocutory basis. And why I find that interesting, that argument so interesting, and why I said this is why I am kind of glad that the Supreme Court did show a little patience as well, even though I'm sure this argument would have just been made on an amicus brief to the Supreme Court. But why no one's being hasty here, and are addressing these issues. The Supreme Court has a doctrine that's called kind of constitutional avoidance, right? Where if they can avoid a major constitutional crisis through some other grounds, they may not address the issue right away. And so if there truly is a procedural ground to say there's no jurisdiction over this, bring this back to us after there's a conviction, that could be a way the Supreme Court can look at this too, or the DC Circuit Court of Appeals can look at it too. Of course, then you get to the merits on whether absolute presidential immunity applies, and then you go through your Judge Tanya Chutkin analysis of the doctrine simply doesn't exist in criminal cases, or you could go to your fallback of the DC Circuit Court of Appeals decision in Blassingame that it falls outside the outer perimeter because it involves interfering with the state's rights to oversee their own elections. What do you make of all of this, Popok? And then I think it's a good segue just to jump right into disqualification.
Yeah. Look, as we expected, the U.S. Supreme Court is going to have to jump in with 2 hands and 2 feet about all things Donald Trump, whether he's going to be on the ballot or not. And we'll talk about that in the next segment or bleed into it. And what's going to happen with the application of immunity for him, and how quickly they're going to make that decision and who's going to make that decision. So just to bring it full circle, you outlined really efficiently the briefing schedule. Got a briefing schedule. It's going to make it all timed out. So by the 9th of January, the DC Court of Appeals, which is the right place for the appellate decision to first be made by a 3-judge panel there, Judge Pan, Judge Childs, and the other judge who's appointed by George W. Bush. And the Supreme Court wasn't patting Donald Trump on the back when 2 weeks ago it said to Jack Smith, yeah, we're going to let this come up the normal course. We're not interested in doing a direct appeal on this. We understand it's an extraordinary matter and it's an extraordinary issue, but it needs to go the normal course. I'm summarizing their thought process. It ended up in a 1-line opinion, and people who don't know better jumped up and down and said, oh, win for Trump, it'll slow down the winds of justice. It's not, because it will be if what happens the way we think it will, in that after the 9th of oral argument, within 3 days, 72 hours, I believe, I think you do too, that there's going to be a ruling by that panel, and it's going to be against Donald Trump. They're not going to set new precedent for the next 250 years of our republic, that a president in office can commit crimes, and that goes without any criminal justice process to address, that he can just get away with the murder if he wants. That's not going to be, I don't believe, the jurisprudence is going to be established in the next 3 weeks by this panel. And then once he loses that absolute immunity, there is no absolute or official act immunity for a president while in office against an indictment. And goes back to your original point about this new amicus brief that we'll talk a little bit more about by American Oversight. Also has to do with timing. The case that we like talking about that happened in the last 2 weeks, that gets now cited over and over again as the momentum of that precedent takes over, the Blassingame case, stands for the proposition that at the motion to dismiss phase, at the very beginning of a lawsuit, before the pleadings are closed, before the trial, it's not the right time, especially in Donald Trump's case, to find that there's absolute immunity at the outer limits of outer perimeter of presidential acts at that moment. Maybe we'll see what happens during a trial. They'll revisit the issue, but they've also laid out the framework in Blassingame that it would be an extraordinary turn of events if the evidence at trial showed us that your acts were within the outer perimeter of presidential authority related to the incitement of the riot that led to personal injury and damage and other things in the civil cases that are pending before Donald Trump. But it is a motion to dismiss moment in time in that case. Similarly here, we haven't done, obviously, the trial of Donald Trump, although we're all chomping at the bit to get there. No evidence has been adduced. No witnesses have been presented. No sentence, no conviction, no sentencing. It's early. It's at the indictment phase. The question is on the face of the indictment. this is what Judge Chutkin, the trial judge, said originally. She says, I'm limited here. The four corners of the indictment have to be taken for true for the purposes of this motion. Everything in there has to be assumed to be true. And then you're asking me whether there's an absolute immunity, no matter what is written in there effectively, that you won't have to stand you won't have to stand in a criminal trial for your charges. And I'm not doing that. And that's where, at this juncture, at the indictment level, I don't believe the DC Court of Appeals three-judge panel is going to do that either. By the time Donald Trump gets to the Supreme Court, through the road of going through Chief Judge John Roberts first, because he's the judge that sits over the DC Court of Appeals, and he's the one that's going to make the decision whether there should be a stay, a continued stay of the trial of Donald Trump in the DC courts that are scheduled for March or not, or he's going to turn it over to the full 9-justice panel to see if there's going to be a stay, and or what the briefing schedule is going to be around the issue. They control, the Supreme Court controls completely their docket. There's no rule book, there's no owner's manual. They decide. They want to do it in 72 hours, they'll do the whole thing in 72 hours like they did in Bush versus Gore. They want to do it in 72 days, 72 weeks, whatever it is going to be up to them. Now, of course, by this logistics timing of briefing calendar, they're signaling what they want to do with the case or how important they see it. If they don't want to interfere with the March trial, they can either take the case up, rule on it quickly, and rule against Donald Trump coming up from the appeal from the DC Court of Appeals that will have ruled against him. So he's already got a foot in the bucket. Or they could just say, this is very, very interesting and fascinating. We want full briefing and oral argument. We'll see everybody in July or June. And they're like, wait, the trial's in March. Exactly. But we'll see you after March. Let us know how that turns out. Now that dovetails into this amicus, this Friends of the Court brief that's been filed. It hasn't been accepted yet by the court, meaning the DC Court of Appeals has the right to accept or reject. They get dozens of amicus briefs. Some of them are like real crackpot briefs, obviously not helpful to their decision making. But some of them, like the two you've identified, one they've already accepted, 5 Republican lawyers and senior officials from 5 Republican administrations. That was the title of the one brief. That got accepted. They want to hear from that group. And we'll talk about a little bit about their Second Amendment, their Article 2 analysis of the presidency and why this particular crime that's been charged can't possibly be something for which somebody has immunity. That's a very unique argument. You and I are bouncing around in a minute. And then there's this other brief that we both liked a lot by American Oversight, this not-for-profit brought by this great law firm, Arnold & Porter, in which they say there's only a couple of immunities that fit the bill for having what's called an interlocutory appeal, meaning in the middle of the case, before there's even a trial, you don't normally get an appellate right. You don't have a right to an appeal. And they're arguing that the DC Court of Appeals doesn't even have jurisdiction, appellate jurisdiction, to hear this issue on an interlocutory or before final verdict and sentencing posture at all. Why? Because under the precedent of Supreme Court precedent, right, law that's been developed since 1989 in the U.S. Supreme Court, you don't take that issue. Immunity is not an interlocutory appellate issue before a trial, to stop a trial, unless there is express textual provisions, an explicit guarantee of no trial, right? And that, if that's the case, then we want to hear that now before a trial. If it's not the case, even if it's labeled immunity, do the trial, see if you get convicted, see if you get sentenced, come back and talk to us. And apparently there's only 2, as you alluded to, there's only 2 constitutional guarantees to avoid a trial if you have immunity. That's double jeopardy and speech and debate clause. If you've already been tried for a crime in a court of law, you can't be tried again, and we're not going to put you through another trial and then tell you, yep, you were right, you shouldn't have had that second trial. We're going to do that early on an interlocutory appeal, therefore appellate jurisdiction. Speech and debate, you are a part of the House or the Senate, and you are doing your function as part of your lawmaking, your rulemaking, not something else, not campaigning, not interfering with the presidential election, but you're doing legitimate speech and debate, trying to get to the bottom, fact finding around that. Great. You can't be sued for that. You can't be prosecuted for that, state or federally. And we're not going to wait till the end of the trial to find out whether we were right or wrong. We're going to tell you right now whether you have immunity or not. But those are the only two. And what doesn't fall into that? This homemade presidential immunity that finds no place in the Constitution and isn't guaranteed anywhere. So their argument is, judges, back out. Let the trial happen in March. Let's see what happens. If he loses, he can come back with the evidence that's been adduced on the record and developed by the finders of fact, the jury, and the judge as the lawgiver, and then we'll come back and revisit it. Now, they haven't accepted that brief yet, but if they do, which has not been argued by Jack Smith's team, not been argued by the lawyers in the team, not been briefed, doesn't mean it can't enter the deliberations, if you will, of the judge, and certainly maybe could travel again to the U.S. Supreme Court along with the other amicus brief if the U.S. Well, not if, when the U.S. Supreme Court takes this issue one way or the other. We'll know that, but towards the end of January. And again, I'll leave it on this. If the U.S. Supreme Court wants to definitively snub this issue out or reward Donald Trump for criminal activity, they can make that decision as early as the end of January, beginning of February, keeping the March trial on track. And I'll leave it on this, Ben. If Donald Trump's lawyers, outmatched and outwitted and out-resourced and out-thought and out-prepared, think that they're going to get away with turning to Judge Chutkan after they lose the series of things that you and I just talked about and saying, Judge, we haven't been preparing for the trial because it's been stayed, and so we need more time, forget it. They have an obligation to prepare for the trial, whether it's been quote unquote stayed or not, so that if the stay pin is taken out and this case goes to trial in March, they are ready. They are not going to be able to get away in front of this judge, nor will it be proper grounds for appeal to say that we've been sitting around and we stopped preparing a month ago because we thought we were right on our appellate arguments. Forget it. If the Court of Appeals doesn't grant a stay, and neither does the Supreme Court, and or they rule definitively against Donald Trump, this trial starts in March, whether Keiss and Blanche and Laura or Haba are ready or not.
And I like that Jack Smith is being aggressive, though. I like that Jack Smith is making Donald Trump respond and declare positions about where Trump stands on issues. Like, we all know now as the public that Donald Trump is saying, if you accept everything Jack Smith says as true in the indictment about the conduct Trump engaged in, and by the way, I accept it as true because it's very, very, very detailed and gives very specific dates and times, and we all saw what happened with our own eyes, or we heard about it, or we learned about it. Donald Trump says, I am still immune. I have the powers of a king. That's what Donald Trump's argument is. So Jack Smith goes, okay, king. Okay, you think you have the power of a king? Why don't we ask the Supreme Court? And then what does Donald Trump say? No, they shouldn't hear it right now. No. Let's delay that. Again, it is as a lawyer, as a American citizen, as just a lover of worldwide democracy, the behavior, Popok, over and over again is just whiny, loserish, kind of victim, just weak behavior by Trump and his lawyers. And it's just like the constant whining and coming up with excuses versus like, own it or don't own it. If you did it, then prove your innocence, but it's always, nah, I'm immune, or let's just delay it and let's wait. And it's that type of just behavior that to me is so abhorrent as a lawyer and just as a human being. And to your point, Popok, Jack Smith keeps filing documents. He just filed a motion in limine. Donald Trump doesn't have to respond to it until the stay is ultimately lifted. Filed a motion in limine. And then I saw Alina Habba go on and call the motion in limine a gag order and said, they are trying to gag us with this motion. Like, Popok, a motion in limine is filed in every federal or civil, criminal, civil case. I mean, state court cases. It's a pretrial motion to narrow the issues that go before the jury so that it's only admissible evidence going before the jury.
Can I
Like
say
Alina
one thing
Habba, I
about
saw her
Habba?
on.
Go ahead,
What'd
finish
you
your
say?
Habba.
I saw Habba.
No,
I
finish
saw
Habba. Go
Habba.
ahead.
Yeah, I saw Habba acting like they're trying to gag us. No, they're filing a standard pretrial motion. You get to file your own standard pretrial motion in limines. You can file oppositions, and the court will determine. It's got to be relevant, admissible evidence that goes before a jury, and its kind of probative and relevant value can't be outweighed by its prejudicial nature. These are standard filings that they act like, oh my gosh, it's a gag order. No, it's a motion in limine.
We started the podcast with my observation that we're going to start a new pod, Legal AF Mishaps and Malpractice by Donald Trump and his lawyers, namely Alina Habba, frankly. To hear Alina Habba comment and give her color commentary on federal practice reminds, I think I used this once on Legal AF. I mean, there's an old joke about you can teach a monkey how to roller skate, but why? It's like what? And it's like watching Habba. They just push her out there to make these ridiculous pronouncements of legal concepts of which she is not familiar. And again, I just want, because I know people, and we don't do it for this reason, but people do take, I think, a tremendous amount of confidence and comfort from when you and I and Karen break down the law and give our legitimate opinions about an analysis about why and how things are going to turn out. And we're fortunately, because we're good at this, we get it right. But our comments about the outcomes, I think, are important because we talk about it from projecting ourselves into the court process and proceedings. We get inside and under the hood of the court filings, the docket. We get inside the courtroom. Either we get a live feed that we can comment on or transcripts after the fact, or we have somebody in the room that we rely on or trust that gives us the information that we need, a feed that we need in order to do the analysis. And the reason we do that is because what goes on in what I like to refer to as the wood-paneled rooms of the courtroom is a completely different universe of which these Trump lawyers are not familiar, that compared to what goes on Newsmax or rallies or social media posts or whatever else. That there is not, I can't tell the public and our audience, there's no greater variance or distinction between the world that you and I reside in the court system, and the world that goes outside. And you can get close. You can go on the courthouse steps and say goofy things. You can get even into the hallway in front of the wooden door and say goofy things that get you gagged or contempt charges against you. But when you're inside the courtroom, it's evidence-based, fact-based, witness-based. And just think about the parade of witnesses, the wealth of witnesses that Jack Smith and the others have put or will put on against Donald Trump. I joked on a hot take that he could spend 3 weeks and just put on former lawyers, some disbarred and or convicted, of Donald Trump against him. Then, if the jury doesn't find that compelling, all these lawyers testifying against their client, their former client, including notes that they took at the time, wait till they bring in all the senior Republican officials, starting with the Vice President of the United States, the Attorney General, not one, but 2 Attorney Generals of the United States, the White House Counsel of the United States, and then all the people that were flies on the wall who were intimately involved with all the decision-making, watching, like Cassidy Hutchinson and the rest. Sure, they're still flipping witnesses. They're still flipping defendants. Don't get me wrong. Mike Roman, we'll talk about him later. Mike Roman better flip on Donald Trump or he's going to go down the drain. But just think about the trial inside the wood paneling. The rest of this stuff, it's like the Wizard of Oz. Ignore that. Ignore that. It's what goes on behind the screen that matters to justice, not this other charade.
Well, to your point, when Alina Habba was having oral argument before the Second Circuit Court of Appeals, they asked her, how does this relate to the Blasingame decision? And she goes, I need to look through my notes. What's that? The Blasingame case? Oh, I don't seem to know that decision, but I do want to talk about the Nixon v. Fitzgerald case. It's Blasingame v. Trump, Alina Habba. It's your case.
And if you're on immunity, you're arguing about immunity. You better know every case up to the minute about immunity.
Maybe the one that was released 2 weeks before or a week before the oral argument that relates to your client. Maybe that would be something that you should know.
All right. There's just one example of what we do twice a week on the MeidasTouch Network on a podcast we call Legal AF. We sit at the intersection of law, politics, and justice so that you don't have to. And if you like lawyers who know what they're talking about legal issues, you've come to the right place. Join us on YouTube. It's free. Subscribe to the MeidasTouch YouTube network. It's no outside investors, independent media network, and you are the network that you've been looking for. With your help and your thumbs up and free subscription, you'll get us to 2 million by the time 2024 is just turning its page. So if you like Legal AF, you know about it already, welcome back. We appreciate you. If you have no idea what we're talking about here, that was Legal AF. I'm Michael Popok, and we look forward to you joining us for our journey. So until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Thanks so much for watching. We're only a few subscribers short of 2 million subs. Please subscribe right now to the MeidasTouch YouTube channel for free and help us grow this unapologetically pro-democracy network.